know if I did that poll correctly because I've never done this before. So if we have some technical difficulties, I apologize. We did a trial run of this yesterday, and that doesn't mean I have it right. So hopefully everybody can see on their screen my slideshow. Matt, can that be seen? Matthew, can you see it? Well, you're muted. Okay. So
Yeah, we
can
see it, Kathryn.
Okay, so hopefully for those of you who have seen me talk before, it's very difficult to come up with new topics. So a lot of stuff is the same thing over and over, but I do try to update it. So I did go and find some new cases to talk about today. The main thing is what I want you guys to know is that there are things that you can do to help you if you do get in a bind, because at the end of the day, it's very difficult to be in your profession and not have the fear of being sued or actually be sued. Unfortunately, just because you've touched a project, you could face a lawsuit. So there are several of my cases where my clients have done absolutely nothing wrong, and yet we are entangled in very big litigation. One comes to mind right now that is ongoing, and everybody except for plaintiff agrees that my guy should not be in the lawsuit. But unfortunately, it is the nature of the game, and you have to play the game a little bit before you can get out. So with having said that, let's get started. So overview, hopefully everyone who is on this call understands what the standard of care is. So standard of care, reasonably prudent professional would do under same or similar circumstances. One of the things that we do when we are defending a design professional is we look to find someone who does the same exact type of work in this area or wherever the project is, to talk about would they have done something different. Now, just like with lawyers, we may not all address the same problem in the same way. It doesn't mean it's wrong. Same with design professionals, and engineers. More than one person may have a different process for getting to the answer. So reasonably prudent, it doesn't mean that everybody's going to act this way, but did you do something wrong? I mean, usually at the end of the day, if a lot of people are going to say, oh, I wouldn't have done it that way, then we're going to have a problem. This duty is non-delegable. So what does that mean? You cannot delegate it to someone else. If you are in charge, you are in charge. We usually look at the contract first to see what your duties are going to be. So why do I say that? Because at the end of the day, the contract is important. Now, for a lot of people on this call, you may not know what the contract says if you're working for somebody else. So what does that mean? I would suggest you know what the contract says, and also always have a written contract. But this obligation to exercise ordinary professional skill and diligence is independent of the contract. So at the end of the day, it's important to be competent in your area and not go outside that area of expertise. And that's the same with us lawyers. I'm not going to go do a will contest and things like that. So I'm not going to do patent law. There are a lot of things that I'm just not going to touch because I'm not competent to do it. So first duty you have is to the person with whom you have a contract, or with whom your boss has a contract if you're working for someone else. And that is why the contract is the first line of defense. It's the first place we go to and that we look at if you're going to be involved in litigation. So that's the most important thing. However, that potential liability can extend to third persons. There is a concept in the law called third-party beneficiary. I did put it on another slide somewhere, where in a contract you can actually put a provision that there are no third-party beneficiaries to this contract. That's actually an issue in the case I just mentioned a few minutes ago with a client of mine who had nothing to do with the design for the project. But it's not just no third party beneficiaries. Liability to third persons could extend to a personal injury as a result of a design failure. So one presentation that we have done before is on the Hyatt Regency collapse. And if I knew how to do these polls really well, I'd do another poll, which is how many of you know about the Hyatt Regency collapse? That is a situation where there were a lot of fatalities when a balcony or not a balcony, but a breezeway fell. And not only was there liability civilly, well known, but it was also criminal liability. So those are considerations. Now, another thing I want y'all to know about is the anti-indemnity statute. So the anti-indemnity statute in the state of Mississippi is for construction. And what it says is that you cannot agree to hold someone else harmless for that person's own negligence. So what that means is if you and I have a contract, I cannot agree to hold you harmless and indemnify you for your own negligence, but you can agree to hold it for someone else. That might be confusing, and I apologize if it is. The exception to this is insurance contracts and bonds, and that is why you have insurance, is because insurance is agreeing to hold you harmless or indemnify you for your own negligence. And I apologize if I talk quickly. I have a tendency to do that sometimes, and I also jump around a little bit. It's a little bit different when you're doing this because I'm just staring at a screen here instead of having some interaction with all of you guys. So going back to this liability, as an engineer, you could be liable to third persons who rely on your contract or your services. It's not always design. Sometimes it is inspection or testing type services. So engineering, as you know, can be a bunch of different things. You can have liability to a contractor for negligent misrepresentation. For example, if you are representing the owner and you represent to the contractor that something's going to be done and you don't, you could be liable for it. Of course, design defect. We all know that one. If you have a design defect and the contractor follows your design to a T and that design is defective, then you could be liable for it. What could you be liable for? Increased costs, things, potentially consequential damages, things of that nature. Especially since that's not someone you had a contract with, and that you could limit those types of damages, which we'll talk about later. You could also be liable to the contractor's surety, because at the end of the day, the surety is going to step into the contractor's shoes in some instances. Now, as I said a minute ago, you can include a contract provision with the owner that there are no third-party beneficiaries, but at the end of the day, some of these things you cannot contract away depending on what your services are. So, for example, if your service is the design of something, it doesn't matter if there's no third-party beneficiary clause, you can still be liable for it. But if it is testing on behalf of the owner for the owner's benefit, that you can have a provision that says that there is no third-party beneficiary. And as I just said a moment ago, liability for personal injuries caused by negligent design. So, how long are you exposed? Hopefully everybody on this call knows about or has heard about statutes of limitation and statutes of repose. So in Mississippi, there is a 6-year statute of repose for damages arising out of design or construction of improvements to real property. That's the key, improvement to real property. If you are part of a project from the ground up, that's a no-brainer. That's an improvement to real property. If it is something with respect to renovation, it may not be classified as an improvement to real property. So that is something you have to think about. Is it a repair or is it an actual improvement? So for example, repairing a roof or even replacing a roof may not be an improvement to real property. Not that you guys are doing roof repairs or improvements. So that 6-year statute of repose has been held to be a limitation period and repose. What that means is that your 3-year general negligence does not run within the 6-year period. Again, I know that may be a little confusing to you, to some of you, because it might be legalese, but what this means is that generally speaking, negligence has a 3-year statute of limitations from the date of injury or the date you should have known. Perfect example, car wreck. If you get in a car wreck, you hit somebody, they have 3 years from the day of the car wreck to sue you. When it comes to providing a professional service that is based on negligence or even contract, they have 3 years if it is not improvement to real property. Good example, you are asked to provide an inspection of some sort or run some tests on soil, but it has nothing to do with an improvement to real property. If it's negligently done, that's a 3-year statute of limitations. But again, if it is an improvement to real property, that 3-year statute does not run within the 6-year. There's one case in Mississippi that said it's a 6-year regardless. I disagree with it. It should be a 3 within a 6-year, but it is what it is currently. So the clock starts at written acceptance or actual occupancy or use, whichever occurs first. How do we determine that? How often? This is another poll question, which real quick, I'm going to give you the first key letter. We're going to do letters instead of words. So A is in apple. So go ahead and write down A. And we're going to give 4 throughout this presentation. So A is in apple. So how often does a construction project actually end up with written acceptance? It's actually very rare. I mean, even on these big projects where you have closeout documents, rarely do we see a written acceptance document. Actual occupancy or use is a lot easier to calculate. And we a lot of times will look at the certificate of occupancy. If the state has, or the county or the city has provided a certificate of occupancy, then a lot of times that can be a date by which we start to run that 6 years. So that's something you want to document for your file. Even if you're not the head person, design professional of record, if you are involved in a project, you want to know when that date starts. Why? Because you want to know how long to keep your project documents. Now, that limitation period cannot be shortened or lengthened by contract. There was a case that came out a few years ago where the homeowner, this was a homeowner and contractor issue, but there was a dispute that came out and they were trying to resolve it. And the homeowner said, well, the contractor said, hey, how about we just not do anything on the statute of limitations? Long story short, they were nigged on that position and used it as a defense. And the court said, sorry, to the homeowner. They said, your claim is barred. You had 6 years and you couldn't extend it. A little shady. And in fact, I felt bad because I had a project one time, Seabreeze condos over in Biloxi. I think it was the Seabreeze condos. We had a situation where the person who sued my guy agreed to dismiss it without prejudice, and we agreed that we wouldn't raise a statute of limitations defense. Well, that case came out afterwards, and I was like, well, if they sue our guy, it's too bad for them. We can raise the defense even though we said we wouldn't. But it is what it is. So we need to know that period of time, because you need to keep your project documents for at least 6.5 years. I would prefer 7. Why 6.5 if there's a 6-year statute? That is because once someone has, what about a company that gives a 10-year warranty? Well, that is a contract issue with a warranty. And you can have a warranty that you apply to a project or to a product, as opposed to a breach of contract or a negligence action. So hopefully that answers your question. So going back to keeping these project documents, if someone has 6 years to sue you, guess what? They can sue you on the very last day. And if they sue you on the last day, and then they have another 120 days to actually serve you with a lawsuit, and then they can even get an extension of time on that, you could actually not get service of the lawsuit until 3+ months after that 6 years has run out. So if you have already gotten rid of all your project documents, that's not going to be a good thing. And especially since we always recommend document everything. You want everything to help your position. So I have in here, beware that some have argued that indemnity actions are accepted from the statute. So what that means is if you're sued and you have a claim against a sub-consultant to indemnify you for their actions, because they're the ones who caused it, and that 6 years has run, people have argued that indemnity is accepted because indemnity does not attach until you're cast in judgment for someone else's fault. I know that probably sounds confusing, but hopefully, you know, at the end of the day, if any of y'all have questions, y'all can always call me. We'll send out my number to anybody, or my email to anybody who has further questions. Further caution on this: statute of limitations do not run against political subdivisions in civil cases. So what does that mean? If you have a contract with a government body, they can sue you at any time. We're dealing with this case, with this situation right now, where a political subdivision has sued the insurance company for damages under an insurance policy. And even though they've known about the damages for over 3 years, they did not file suit until 5 years later. In a normal breach of contract, that would be too late, but the law says that it does not run against the political subdivision. So beware of that. So you may want to think about longer document retention if you are contracting with a state or political subdivision. So let's talk about a few cases, and hopefully these will make some sense to you. So first case, that's a more recent case, American Contractors Indemnity, which is ACIC versus Reflect Tech. So this is one of those situations where anti-indemnity does not apply because this is a contract between an insured and insurer. So in this case, a demand was made under a performance bond to complete work, and Reflect Tech was refusing to perform this corrective work because it wanted additional compensation. So because of that, the owner made a claim under the performance bond. So again, I would think all of you know that if you are involved in a public works project, the contractor has to have payment and performance bonds. So in this case, that happened, and the insurance company retained counsel and an engineer to investigate and ultimately resolved the claim. And there were also some additional performance bonds. And after that, ACIC sued its insured for reimbursement under that indemnity agreement. And so the issue was whether that indemnity contract was unconscionable and unenforceable. So what that means, and we'll talk about it on the next slide, is that indemnity provisions in contracts they have to be rock solid to be enforced. So unconscionability is a legal term that a defendant will use to try to get out of or wiggle out of a provision. So what the court said is that when we look at whether a contract is unconscionable, it's one that no man in his right mind would enter into. And on the other hand, no honest and fair man would accept. So there's two types of conscionability: substantive and procedure. So substantive, 4 corners of the document. Are the terms oppressive, one-sided? There's no meaningful choice, those types of things. And by the way, I know that some of you, especially in the private sector, a lot of times you may end up contracting with these bigger contractors, and it's a take it or leave it form. Those can still be enforceable. the courts won't necessarily find that terms are one-sided. So be careful and read these contracts that you're given. Procedural unconscionability is whether circumstances surrounding the formation demonstrate lack of knowledge, voluntariness, is it inconspicuous, those types of things. Maybe a lack of opportunity to study the contract. In this case, the court found neither existed, and the insurer was entitled to recover all amounts paid plus interest and attorney's fees. Now, I understand y'all aren't contractors, and so you're not going to be dealing with performance and payment bonds necessarily, but I just want you to be aware that indemnity agreements are enforceable and they can subject you to payment of interest and attorney's fees. So you need to balance the risk of performance with potential exposure. For this case, what that means is that had Reflect Tech just balanced those two things and thought, well, how much is it going to be for me to do this work versus what I could potentially be cast in judgment, they may have been more willing to go ahead and proceed as opposed to letting the bonding company pick it up. So next case, Waltman versus Engineering Plus. In this case, the county hired an engineer for roof repairs, and the engineer prepared all of the details, contracts, bid paperwork, etc. This case involved a employee that fell through a deteriorated portion of the roof, and he sued, claiming the engineer should have warned him of a dangerous condition. This case is one of the more recent cases in a line of cases that talk about the duty to warn of dangerous conditions on a project. Now, if you've heard me speak before on various cases, no doubt you guys have heard me talk about Jones versus James Reeves Contractors and Hobson versus Wagner Engineering. Those are the two cases that started the line of cases talking about the duty to warn. Hobson was with respect to an engineer, and Jones was with respect to an architect. And at the end of the day, what is become the law of the state of Mississippi is stated right here on the slide. So absent an undertaking by contractor conduct, a design professional has no duty to warn of hazardous conditions on a construction site. So where does the court look? First, it's going to look at the contract as a whole to determine, was a duty assumed? Now, in deciding whether or not there's a duty by conduct, the court's going to look at what has been called the Hannah factors, which I've listed here. I'm not going to sit here and read all these things to you, but there are these Hannah factors that the court will look at to determine whether or not conduct by the design professional results in this duty being assumed. So the lesson is, have a contract, know it, and stick to it. Now, this conflict that I've listed on this slide actually was one thing that I discussed with the engineering students the last time I spoke on the ethics or contract with the engineering students at the ASCE meeting 3 years ago, I believe. How do you reconcile this principle with the ethical duty to protect the safety and welfare of the public? Seems like a conflict, right? Here's what I would suggest. You do not want to go beyond your contract, but if you see something that you know is dangerous, what I would suggest is you write a letter to your client and you say, I am not undertaking a duty. However, please note this. So you would want to frame it in that I am not undertaking any duty. I am, and then you look at these Hannah factors, you say, I'm not supervising these people. I'm not demanding anything being stopped. However, I want to note that this is going on, because the owner's going to want to know as well. So you can protect yourself with a disclaimer saying, I am not undertaking this duty. Now, one thing that I've argued recently, and we will see how it plays out with the court, is in the case I mentioned a few minutes or earlier in this presentation about my client having nothing to do with the design of a particular project. In that case, which is a still ongoing case, it involves the failure to disclose underground debris, which resulted in extra work. And the allegation is my client had been on this project site for so long and he knew of this debris and failed to warn. And I've actually used these two cases to say it doesn't matter if my client knew about debris under this site. His contract had nothing to do with warning because he was only there to register blow counts during construction, and he didn't undertake by any conduct to warn of debris. And of course, the plaintiff has distinguished these cases from our case, saying that, well, these two cases, or three cases now, concern failure to warn of a hazardous condition. And my position has been, well, hazardous condition is a little bit more serious and important than, whether or not debris is going to impact a site. So it should be the same ruling. That's currently before the court, and perhaps next time I speak with you guys, we'll have a decision. So next case, and let's go ahead and give the second letter. It is K. K is in kite. So this next case, McKean versus Yates Engineering. So this case involved an expansion, and if you've heard me speak, you've heard me speak on this particular case before. Yates Construction was a general contractor, and at some point it retained Yates Engineering to design scaffolding formwork. Well, before Engineer Pope even provided a preliminary design, Yates Construction had already begun building some scaffolding. Now, it was undisputed that Pope's plan was flawed and impossible to follow. Yet Yates Construction had no comments and asked for final drawings, which Pope complied. At the end of the day, Yates did not follow the design, or there was no evidence it followed the design. And long story short, scaffolding collapsed and plaintiffs were injured. So the issue was whether Pope breached his duty to provide a proper design and breached a duty to inspect the scaffolding after construction. And these issues were presented after Pope was granted summary judgment. So what did the court rule? It went through the duty to exercise ordinary professional skill and diligence. However, there has to be a causal link. Why is that? Because negligence requires four things, everybody, four things: duty, breach of duty, a causal link to the damages. So duty, breach, causation, damages. And so just because you breached a duty doesn't mean you caused damages. And in this case, because there was no evidence that Yates Construction even used the design, and because the design was impossible to follow, there was no causal link. So this case was where the court adopted those Hanna factors that I mentioned a minute ago. And that was in reference to the duty to inspect the scaffolding. And the court said only in limited circumstances would the design professional have a duty to supervise construction site. So the lesson here with respect to design is make sure your design can even be constructed. In this case, the issue was the way that it was designed. I don't know exactly how to explain it, but the contractor would have to splice beams and connect them because there were not beams, I guess, long enough to do this design. So ensure your materials are available to construct it. Also, stamp not for construction. I'm sure all of y'all have heard that before. You don't want plans getting out there that are not for construction. So, and then also, if no inspections contracted for, don't do it. Don't do it. So next case, and that's why that prior case was out of order on our time. So I was trying to go in order from most recent and then so on and so forth. Land Holdings 1, this is a more recent case as well. One presentation I've given in the last couple of years, or last 6 years now, is Mississippi's new lien law. So I have a presentation on that if anyone's ever interested in hearing about it. But prior to April of 2014, design professionals did not have lien rights unless they had a direct contract with the owner. The new lien law changed that, so you no longer need a direct contractual relationship with the owner. You still have to give notice of your contract and things like that, but that's not at issue here. So in this case, the casino contracted with SITS for surveillance systems, and SITS subcontracted with GSI. Even though the casino paid the entire contract amount, SITS withheld a portion because GSI had not fully performed. GSI filed a notice of claim and proceeded to seek to enforce that claim, and the casino's defense was it was not filed within 90 days of last work performed. So the issue in this case was, what is date of last performance? Because the casino was arguing that the work was corrective and mere punch list items, and the casino wanted the court to interpret last work performed as it is interpreted under the Miller Act and the Little Miller Act. Now, for those of you who do government work, the Miller Act is the act that is for federal projects that says that a contractor has to have payment and performance bonds, and there are certain procedures that someone has to do to be able to enforce a lien under those bonds in that act. The Little Miller Act is the Mississippi version for state projects. So the court ruled that the Miller Acts are for public projects and concern payment and performance bonds. But this case was a private project that concerned a lien. What the casino argued, as I said a moment ago, is that the Act's language does not include remedial or corrective work, even when performed as under the contract. And they wanted the court to interpret the lien law in the same way. But the court rejected that argument because they found that the lien statute was unambiguous. So statutes and laws are going to be enforced as written when unambiguous. So under Mississippi's lien statute, the subcontractor has 3 months after last work performed, labor, services, or material provided. In this case, the subcontractor was able to show it provided labor, services, or material within 90 days of filing the lien. So I tell you this case because, as I said a moment ago, engineers now have lien rights. And if you're having difficulty getting paid, make sure to calendar the deadline to assert a lien. As I also said a few minutes ago, there are some other things that you may have to do, but it's important to know these rules and these statutes to have a better understanding so that you can protect yourself and get paid. So the next case we have is Warnock Engineering versus Canton Municipal Utilities, CMU. So here, this was interesting. So you had Warnock as an engineering firm, but you also had the owner, Mr. Warnock, and he agreed to provide engineering services for the public utility that was managed by a 5-member board. After this agreement had come to fruition, the CMU ended up exclusively using Warnock for all of its engineering work. And weirdly enough, later the CMU voted to place Mr. Warnock on the personnel committee. It wasn't discussed in this particular opinion, but I thought that was a weird type of thing there. It could have been an ethical issue, but I don't know enough about the personnel committee and how it relates to CMU to know if that would have been an ethical conflict, but that was not an issue. Mr. Warnock voiced concerns over board member Anderson because he was soliciting kickbacks. The opinion talked about him asking to kill some people, murder for hire type stuff, just some crazy things. That's that among other alleged conduct. And as retaliation, Anderson sought to have Warnock removed as the engineer. And after that, the contract was in fact terminated. There were actually 3 contracts at issue. That's irrelevant for this summation. But after termination, Warnock sued and alleged that it was owed fees over $2.3 million, and he also sued for wrongful termination. So the issue was whether Warnock had a valid contract with the CMU. So, breach of contract requires a valid and binding agreement that was breached. So I hope you all know, if you're in the private sector, that if you have a contract with a government body, a public board can only speak and act through its minutes. You have to have a quorum. In this case, that would be 3 out of 5 people of the CMU board. And all proceedings must be entered upon the minutes. It is the responsibility of the person seeking to have the contract, which would be in this case the engineer, to ensure that the contract was legal and properly recorded. Placing the contract in a book other than the minute book or in a file is insufficient to meet that minutes requirement. You also cannot attach it after the fact. So it has to be contemporaneous at the meeting in the minute books. Now, the entirety of the contract need not be reproduced within the minutes, but you have to have sufficient information to determine the liability of the parties without resorting to other evidence. In this case, none of the 3 contracts were properly recorded, and thus they were not enforceable. As an aside, the court did allow Warnock to proceed on the retaliation charge, but the 3 contracts themselves unenforceable. So, lesson here: know and understand the requirements of a binding contract. This would apply not only with the boards, public boards, such as in this case, but it's really any person that you're going to contract with. You need to understand what makes a binding contract. 2 or more parties, you have to have competency, sufficient consideration, those types of things. Legality of contract, you can't contract for something illegal. And at the end of the day, it never hurts to have someone look at it for you. Next case, this is one I've talked about previously, Williamson Pounders Architects versus Tunica County. Now, in this case, the contract was properly on the minutes. That was not the issue. Instead, the issue here was whether or not a requested change order was properly done through the contract's formal notice requirements. So this was one that also involved a subcontract with an engineer. There was no dispute that there were changes that were requested in the design that increased the complexity by $6 million. Ultimately, what happened was, after a meeting, the county denied further amounts were owed, and the architects sued the county and the governing board to recover over $203,000. The court found the architect could not recover because it failed to provide the required contractual notice. So that was the issue, whether notice was given or if there was no formal notice as the contract required, whether the architect could recover under the theory of an implied contract. So real quick, as an aside, if this were not a governing board or something of that nature, regular persons can have a contract without it being written, unless there's this thing called the statute of frauds. That's a whole nother thing. But contracts that aren't of a certain time period, of certain types of contracts, you can have an oral agreement. It just makes it harder to enforce. So that's why written contracts are so important, signed by both parties. So in here, in this case, the court found there was no doubt that a February 2002 meeting occurred regarding increasing the scope, and that the parties discussed these additional costs. But under the terms of the contract, a meeting was not enough to provide notice, because the contract had a 2-step process for effective notice. A, there had to be a change in scope, and B, the change had to then trigger written notice. So under the plain language of the contract, which again is going to be enforced as written, change in scope alone was not enough. You had to have written notice. As such, the architect could not rely on a meeting to discuss a change in the scope. Also, Mississippi has explicitly held oral contracts cannot be formed or by or against a county board or supervisor. Again, it has to be in the minutes. So here, again, know your contract, follow the contract. Obtain written change orders before proceeding with additional work. Make sure acts of the board are in the minutes. I mean, how often do people have a meeting and they say, oh, well, go ahead and start doing the work and we'll worry about the change order later. Proceed with caution on that. I wouldn't do it. I would get the change order written. I would make sure it's in the board minutes if with a governing body. Walmart versus Core. Now on this one, this was a situation where Core had two contracts, one for geotech investigation and the other for testing and inspection during construction. The first contract said each party was to bear its own expenses, and the second contained an indemnification clause. After completion, there were signs of stress and failure in the parking lot. The jury found in favor of Core under the first contract, but 10% liable under the second. And the court thereafter awarded Walmart $810 in attorney's fees. So the issue was whether and to what extent Walmart was entitled to an award of its attorney's fees pursuant to the contract. So in this case, you have two different contracts with two different provisions, two different things you have to look at. So the court found that the winning party may only, and this is black letter law, by the way, in Mississippi, a winning party may only recover attorney's fees in three circumstances: contract, statute, punitive conduct. Punitive conduct is not easy, especially in breach of contract situations. It's not impossible, however, mainly because oftentimes breach of contract actions also include negligence, especially if you do not, you can have a grossly negligent performance of a contract. What's an example? Well, I can think of an example right off the bat. If you have a contract to perform engineering services and you agreed to design, well, let's just take the Hyatt Regency collapse, and you agreed to provide a design for this building, and you're a structural engineer, and you are going to design this project. You have a duty to calculate loads, and if there's a design change, you have to redo your calculations. And if you don't do that, that is grossly negligent, and you open that door to punitive damages. That's punitive conduct, even though you had a contract. In that case, also criminal liability. So in this case, the court went through that, talked about when the contract is clear and explicit, the intent of the parties must be sought within the four corners of the contract. So if a contract is clear and unambiguous, the court will enforce it. So in this case, the second contract's plain language allowed for recovery of attorney's fees. However, that duty to reimburse attorney's fees was limited to the fees proximately and legally caused by the negligence under the second contract. So what does that mean? That means Walmart doesn't get its attorney's fees for the entirety of a lawsuit under two contracts. It has to be those shown to be legally and proximately caused under that second contract. So here, what I would like you to consider is, if you are entering into a contract, consider the inclusion of a provision to limit such recovery, not just recovery of attorney's fees to the prevailing party, but also limitation of liability clauses, waiver of consequential damages, those types of things, which we'll also talk about in a moment, but not right now. So the next case, U.S. versus Bryan Company. This is one I was personally involved with. The Department of Justice sued the contractor, owners, and engineers, architects for violations of the FHA and ADA in 9 apartment complexes across 3 states. The Bryan defendants were the owners, contractors, and developers of all 9 complexes, and the ADA claims were only against Bryan. Bryan filed cross claims against the design professionals, including my client, who was an architect for 3 of the buildings, if I recall correctly. And Bryan asserted that if Bryan was held liable in any way for the violations, that the design professionals were responsible for that judgment. Now, there is contractual indemnity, but there's also common law indemnity. For common law indemnity, you have to show that that the other person is legally responsible or legally caused something that you are being made to pay because you're legally obligated to the party making the claim. But you also have to show that you yourself are not negligent, maybe only passively negligent, but not actively. That was not an issue in this lawsuit. Instead, the issue was whether the FHA and ADA preempted cross claims for indemnification because they are regulatory and non-delegable statutes. And that was the whole issue. And since this case, it's actually been cited again. The ruling was that the cross claim had to be dismissed because the Bryan defendants could not shift liability. An indemnification claim in this context would frustrate the purposes of the statutes. This case was very difficult because, as you all can likely understand, if you draw a plan that is fully compliant with FHA and ADA and the contractor does not follow that plan, the DOJ does not care, because under these cases, the court will say that it's a non-delegable duty. So if the architect drew up, in this case also, if the architect drew up inaccessible building plans, the Bryan defendants failed to correct them. So it goes both ways. Both sides may have exposure. The court went on to say that if developers and owners knew they could shift liability, they would have little incentive to self-test and discover potential violations. But at the end of the day, developers and owners remain independently responsible, and they should therefore check the architects and contractors before and during construction. So here's the lesson we're talking about here under this case. As a design professional, if you have a project that involves accessibility, FHA or ADA, you could be joint and severally liable with the contractor. DOJ does not care who pays as long as retrofits are performed. DOJ, my former boss who retired, he used to say, the DOJ does not have any sense of humor. In this particular case, we kept saying, hey, look, we don't have liability for someone else's fault. The other problem we have is insurance does not cover errors and omissions of the contractor, nor anyone else. Your errors and omissions is only going to cover your fault and things that you failed to do. So if the FHA applies to the project, make sure your plans comply. And if you have some construction administration, make sure that the contractor bills according to those plans. At the end of the day, I will say that as long as your plans are 100% compliant, if you do not have a legal duty under your contract for inspection, there is a better defense to it. But they are very difficult cases. They're expensive cases, especially the ones of this kind of magnitude that included so many different projects. And this was one of those where they even went out to the sidewalks and they were complaining that there wasn't a sidewalk going out to the road, even though there was no sidewalk at the road. It's just nitpicky, ridiculous. And hopefully none of y'all have to deal with the DOJ in these types of cases. Not to mention, they will send out notices to anybody and everybody trying to find victims of the discrimination or alleged discrimination. We only have a few more cases. Thrash involved a situation where they subcontracted with Tarragon consulting engineers to perform lab testing. And instead of testing the soil every 1,000 square feet, they only tested it every 2,500 square feet. When the error was discovered, the Bureau and the architect required Thrash to hire an independent testing lab. And unfortunately, the density did not meet design specifications, so Thrash had to remove the top 6 feet of fill as well as concrete footings and reinstall both. Thrash then sued Terracon for breach of contract and breach of duty of good faith and fair dealing and wanted over $300,000. Now, the issue in this case is whether a limitation of liability and waiver of consequential damages provisions in the subcontract were valid. This is a very important case. And if any of you want a copy of this case and this next slide, like I said, call me or email me. We can certainly get you that information. Matthew will have it as well. This is the subcontract provision at issue. I've underlined limited to greater $50,000 or its fee. I'm not going to read this entire slide to you, but I will tell you at the end of the day, the court found this was a valid and enforceable provision. And that's why I like it, because it's already been upheld. Not only the limitation of liability clause, but also the consequential damages clause. Another consideration for your contracts would also be, we have here, limitations shall not apply to the extent of damages paid under the commercial general liability policy. I like to see my engineers and architects have a provision in their limitation of liability that it's limited to collectible insurance. Why do we say collectible insurance? If I could do another poll right now, I would ask you all to tell me how many people know what that means, but I don't know how to do that. And before I get into that, let's do the next letter. B as in boy. B as in boy. Hopefully everyone got that. B as in boy. Now, collectible insurance. Design professionals, your A&E, errors and omissions policy for engineers and architects, are wasting policies. A wasting policy is a policy that is diminished by all attorney's fees and claim expenses incurred. So if you have a $1 million professional liability policy and you're sued and it costs $500,000 to defend it, including attorney's fees, expenses, experts, you only have $500,000 left to pay the claim. Also, if you have another claim against the policy, that too is diminished. I have a case right now where that has happened, where the policy has been diminished by not only another claim, but also attorney's fees. And so now there is not enough money left on the policy to pay if it's a slam dunk for plaintiff. Not my fault. Didn't even know about the other claim. It is what it is. So collectible insurance. So in this case, the court ruled that clauses that limit liability are given strict scrutiny, but as long as it is fairly and honestly negotiated, it can be enforceable. So in this case, Thrash did not make any written request to negotiate a higher limitation of liability clause. Now, it had in there, it had in here somewhere that they could talk about it. Let's see. Evaluated the risk and rewards and agreed to allocate certain risks to the fullest blah, blah, blah. Anyway, it's in here somewhere. Risk Written request for consultant. Consultant may negotiate a higher limitation of liability. It's third line from the bottom. So in this case, Thrash did not make any written request to negotiate a higher limitation of liability. And because Terracon's fees were roughly $15,000, but it assumed a risk of $50,000, that was an adequate incentive for Terracon to perform. So what I will say again is this is a very important risk management tool for your contracts. Think about what your fee is and what you're assuming as your risk. So the court found a limitation of liability clause will be found unenforceable if the liability is so minimum compared to the expected compensation. So it has to, those are consideration. Now, a limitation of liability clause is different from an indemnity and hold harmless clause. So statutory restrictions on anti-indemnity clauses do not apply to limitation of liability. Remember, we talked about anti-indemnity earlier. The court also concluded the waiver of consequential damages was enforceable. That's another very important thing in your contracts. Consequential damages, limit those as well. So here, lesson, these types of provisions are very effective risk management tools to limit your total liability, but it must be reasonable. You want to make sure that these clauses are conspicuous. You can even have the other party initial next to those clauses. And you need to consider reasonable damages and your insurance policy limits. So very important considerations. Employers Mutual versus Sawyer. In this case involved a DEC action. That's a declaratory action. A declaratory action is a lawsuit where you ask a court to declare the rights and responsibilities between parties. In this case, the Sawyers averred the engineer negligently performed soil testing prior to construction of a home. And the insurance company wanted to know or asked for declaratory action of whether or not it owed defense and indemnity to the engineer. Now, real quick, I want you to know an insurance company has two different duties under an insurance policy. One is the duty to defend, and one is the duty to indemnify. The duty to defend is much broader than the duty to indemnify. The duty to defend, as talked about on this next slide, is where it's the 8 corners test. The court will look at the 4 corners of the complaint and the 4 corners of the insurance policy. And if there is any claim stated in the complaint that could fall within coverage, then the insurance company must defend the entire thing. The duty to indemnify is much different. An insurance company only has to pay a claim for what is covered under the policy. Here's an example. If you have an insurance policy that says the insurance company will not pay for punitive damages, and you are sued for negligence and gross negligence, and at the end of the day, the court finds you liable for $100,000 in compensatory damages and $100,000 in punitive damages, the insurance company only has to pay the $100,000 compensatory. They don't have to pay the punitive. So, but they would have to defend the entire lawsuit, including defend against the punitive damages allegations. So hopefully that's clear on those two duties. So in this case, this particular insurance policy excluded errors and omissions, and it also had a professional services exclusion. So under this particular policy, the insurance company had no duty to defend or indemnify. So what's important here? There's different types of insurance to cover different events. CGL, commercial general liability policies, exclude actions that typically fall under an errors and omission policy. So you need to discuss with your insurance agent the types of insurance, and you need to evaluate what kind of insurance you need for your business. There are plenty of design professionals that have both, and several different types of insurance. So I only have a few minutes left because I actually have been timing this over here. Is litigation avoidable? Of course not. As demonstrated by the case I talked about earlier today, where my client had absolutely nothing to do with the design of the project and was only there for materials testing on behalf of the owner. He's still involved in a lawsuit that has already cost probably about $200,000. Well, no more than that, with attorney's fees and expert fees. It's probably $300,000. So he currently only has probably $700,000 left to pay a judgment. So litigation's not avoidable. So what can you do to protect yourself? Consult with your insurance agent. Are your services covered? What you're doing day in and day out, is it covered under your policy? Here's a very important one. Does your insurance company provide contract review? I don't know if they still do, but I know at one time CNA through Schinner did provide contract review. What they would do is they would take your contract and say, yes or no, your services are provided. Insurance is going to cover that. It would also say, well, insurance is not going to cover this part of your contract. You can still do it, but just know that insurance is not going to cover that part of your contract. Does your policy provide pre-claim assistance? What is pre-claim assistance? That is where you feel you might get in trouble, so you let your insurance company know, and they will provide a lawyer to help either resolve the issue or avoid it altogether. And I'll talk more about that in a moment. Have a written contract with a well-defined scope of work. Now, no Schinner will do this for their insurance. Okay. So have a written contract with a well-defined scope of work. It's impossible to say in a contract everything you will not do. I get it. It's just impossible because that's infinite, things you will not do. But if you can at least check off the most obvious, important things that could come up that you will not provide, it will help. And also stick to that scope of work. As I discussed a moment ago, consider the limitation of liability clauses and waiver of consequential damages. Be wary of indemnification clauses. Here's an example of that. While you cannot agree to indemnify your subconsultant for your subconsultant's own damages, you can always agree to indemnify other people, and that's where you might get in trouble. So you want to make sure that if you're going to have an indemnity clause, you will only indemnify, you only want to be responsible for what you have done and what your employees have done. That's it. If a task is outside your area of competency, get a subconsultant or don't agree to perform it. I would say if you're going to get a sub, again, that's another good point from John Rayner. Design, you do not guarantee a perfect design. And that's just how it is. You only agree to perform to the applicable standard of care. Follow your contract. What's the point of having a contract if you're not going to follow it? No relevant rules and regulations. Now, this isn't just the statute of limitation, ADA, FHA, lien law, contracts with government. Any area that you are practicing in, you want to make sure that you know what is relevant to your specific area. Review and update your internal policies and procedures periodically. This would involve your document retention and how you store project documents in general. Maintain project files for at least 6.5 years. I'd really say more like 7 or maybe even 10, because that's the main thing. You want to make sure that you have your entire file available in the event something happens. Document, document, document. Now, final slide, as we're right at hitting the hour mark. And by the way, let me give you let me get through this slide and then I'll give you the last letter. So what do you do when litigation comes knocking on your door? Notify your insurer even if no claim is made. Typically, a claim is a demand for money or services. But if you think something is going sideways, go ahead and notify your insurer. Why? A, they may have pre-claim assist. B, if you don't and it becomes an issue, you don't want to get accused of failure to promptly notify. Do not appear for a deposition without counsel present. Last year, CNA asked me to appear for an insured's deposition. He was not a party, but he was one of the engineers on the project. And it was funny because the plaintiff's counsel was like, why do you have a lawyer here? Well, just to make sure everything goes right. Why? Because if he says something wrong, he can be drug into the litigation. That happened to a client for a partner of mine. The guy appeared for a deposition and then ended up getting roped in and sued as well. So don't appear for a deposition without an attorney present. Put a litigation hold on project documents, including electronically stored information. That includes emails, anything you want to have it backed up. You want to have it held so it's not automatically erased. If you have a system, for example, that might delete emails after 90 days, make sure everything is preserved. You certainly want to do that because if you don't, you could be accused of spoliation of evidence. Do not ignore subpoenas or service of lawsuit papers. If you are given a subpoena, again, you might want to get an attorney to help you figure out how to properly respond. Service of lawsuit papers. These things have deadlines, and if you don't comply with these deadlines, you can get in more trouble. Especially with the lawsuit papers, even if you're served with a lawsuit and you submit it to your insurance company, do not assume it's taken care of. I have a case where the insured, my client, timely submitted it to the insurance company, and the insurance company dropped the ball. They forgot, I don't know how, but no lawyer was assigned to the case and a default was taken. I got the case once after a motion for entry of default judgment was entered. And the case law says that it is the defendant's duty to make sure the timeline, the deadline is complied with. It's non-delegable. So just because you submit it to your insurance company doesn't mean you're off the hook. Now, ultimately, it would be up to the insurance company to pay the judgment, but what you don't want to happen is something not get covered, but make sure it's taken care of. So what does that mean? Be involved in the process. Don't be one of those annoying people who has to call all the time. But be involved, look at things, give opinions. If you receive a reservation of rights letter, know you're entitled to independent counsel, because at the end of the day, not all insurance companies are going to be the best, because at the end of the day, it's a business and insurance companies want to pay as little money as possible as well. So with that being said, the final letter is P as in Paul. P as in Paul. And if there are no questions, like I said, you can submit them to me independently, or you can email Matthew Hosey, which you need to email him for credit. Let's see, on these types of cases, do attorneys often try the veil of an LLC the whole? Okay, so that's a good question on LLCs. Now, an LLC protects the members of an LLC. So if you are a member of an LLC, you cannot be sued just because you are a member of the LLC. But if you are a member of the LLC and you actually perform the work, you can be sued. So if at the end of the day, if you are an engineer on the project, just because you work for a company, you can be sued just like your employer can be sued under the doctrine of respondent superior vicarious liability. So it doesn't happen all the time. Sometimes plaintiffs will just sue the company. But often they will also sue the individual because they have more what's called discovery control. That answer that question. All right, we're a little over an hour. Sorry about that.
No, you're all good, Kathryn. That was very intriguing. I enjoyed it thoroughly. I know a lot of our members probably did as well. Luckily, knock on wood, I personally have never had to step foot in a courtroom for my professional services. Of course, my career is still relatively short, but hopefully that will hold true for the remaining of it. But no, all